And tonight, approval of Justice Gertrude Tokono as Chief Justice set to come down to a vote as the National Democratic side, Congress side of the Appointments Committee serves notice. Her vetting will only be concluded if they have the chance to question her on James Gyakye Kwesine's judgment.
We will not vote on you today after this hearing.
We are of the view that we should be given opportunity to get a copy of the ruling so that we can be able to ask her questions based on her ruling.
There's more unfolding as Justice Tokono herself says she would prefer for her work as a charge to be analysed as a whole rather than limited to that decision, which will be released by the Apex Court on June 7.
And my answer is that I have given hundreds of judgments from High Court till now. And I think that it would have been a really great relief to know that I am assessed on my work as a whole.
Plus, we hear from Chairperson of the Appointments Committee, Joseph Osei-Wusu, who, however, says the unavailability of the judgment does not stop the committee from concluding its works.
Please, let's not appear that because a judgment of a court, not her judgment, the Supreme Court, you have not had a copy, it in any way precludes the Appointments Committee from concluding its work. I don't think we should encourage that kind of...
And this is Top Story. My name is Blessed Sugan. Tonight, the Appointments Committee is sharply divided and likely to settle matters via a vote. This is on the issue of the approval of the Justice of the Supreme Court, Gertrude Tokono. The minority side today took their concerns regarding the Supreme Court's decision on the James Gyakye Kwesine case directly to the nominee. Justice Tokono was part of a 7-member panel that unanimously ordered Parliament to expunge Mr. Kwesine's name from its record. The court indicated that it will make its full judgment available on June 7. The minority side says it can only conclude on the vetting if the questions are put to her about this very decision.
We've been able to secure most of the rulings and the judgment from that she was able to participate on. So that is largely what we will be doing. Unfortunately, there is one of them that we are not able to get the reasoned ruling on the matter. That has to do with the recent case involving our colleague, the Honorable Kwesine. We are of the view that we should be given opportunity to get a copy of the ruling so that we can be able to ask her questions based on her ruling. We are going to start the vetting, obviously, using the information that we have. But unfortunately, we cannot conclude on the matter until we have the ruling on the latest judgment for that she took part. So, Mr. Chairman, I think it's pretty straightforward. It's pretty straightforward. As I said, she's not new to us. She's been around for some time. And we will start the process of vetting. Thank you, Mr. Chairman.
Very well. Enough members will start. My Lord.
And so that's the position of the minority leader, Kesa Letofosun, indicating what it is that the minority has concerns with. Member of the Appointments Committee, Mahama Ayariga, says the NDC side actually wanted to stay away from the vetting.
We would have thought that on a matter in which we were so divided in terms of the two political parties, a matter that was litigated from the very day in which this parliament was sworn in, the night of the swearing in of this parliament, till the 17th of May when you gave your ruling. It's a very divisive matter. We thought you would have carried all of us along by giving a reasoned judgment. Because when you give the judgment and you don't give the reasons, in between, people fill it with propaganda, speculation, and that just divides the country. Doesn't help us to move along together as one people. So we wanted the reasoning in that judgment to be able to really evaluate you, in addition to all the things that you have given us. But we've reached a negotiated position with our colleagues in which we've been assured that we will not vote on you today after this hearing, and that when we finish today, when the Supreme Court gives the reason, we will have another opportunity to now assess you on the basis of the quality of the reasoning of the court, and then we can take a decision. On that basis, I have no question for you today. I would wait for that day when we have the opportunity, and I will focus my questions on the reasoning that you will give in that matter.
And so that's where all of this ended, with the minority firmly sticking to their side of the story, that they would have to wait until June 7 to decide. But what does the nominee herself make of this concern from the minority group? My colleague James Kuziavaji has been monitoring the process. James, we have heard from the nominee, but on this particular issue about the decision of the minority side to defer their vote on the matter until June 7, how is she receiving that?
Yes, bless. So initially, she would not want to respond into detail to this matter until it keeps recurring in the questions of the other members of the committee, including the majority, especially when Honorable Hassan Tampuli raised that concern again, that he's noticed that the minority side of the House seems to be very interested in it. And so then she said that she would want, since the matter has become a matter of public interest, she needed to explain and use the opportunity to educate the public and the committee members on the work of the committee. And so she was of the view that in fact the judges on the Supreme Court cannot sit on any case unless at least 5 of them is present. And when they sit on a case and comes to a judgment, every individual judge on the case needed to submit a written ruling on the matter, which will be compounded into a Supreme Court ruling. And so it is not the case that, despite all of the work she's done, should be narrowed down to one particular ruling that she has been involved in.
And my answer is that I have given hundreds of judgments from High Court till now. And I think that it would have been a really great relief to know that I am assessed on my work as a whole. And then two, the judgments of the Supreme Court. You know, the Supreme Court is not a court unless 5 people are sitting. And in constitutional matters, we are 7. So 7 people are working together. And that's why very often, indeed, almost invariably, every judgment given by the Supreme Court comes out, the reasons come out long after the orders and the rulings, because that's how we work. Everybody has to check the jots and the tittles before you get the final script. The way our court works, we sit in conference. We sit in conference over every decision, every matter before us. As I said, it's not a court unless there are 5 people or 7 people. And so all these people will sit in conference everybody will present their position, their evaluation. We will agree the orders, the conclusion. We will craft the orders and the rulings. We will share it. Everybody will approve. And then it will be written. Sometimes I have actually been on a panel in which different judges wrote different parts of the judgment. It was a very interesting experience. Sometimes one person will write it. Sometimes more than two people will write it. And in this particular situation, we had concluded on our orders and rulings, and we gave that to the public. And the judgment is currently a work in progress.
But in all of this, James, the minority side is still not satisfied. Why?
Indeed, Blessed, they were not satisfied because when the matter still went around the table and came back to the minority leader who gave the earliest indication in his opening remark, and he re-echoed the point that, look, as they stated at the beginning, that decision, the reason for the ruling on the Judge question matter would have to be given to them to form the concluding remarks of their side of the appointment committee.
How does Parliament expunge Honorable Kwesi's name from Hansard, for instance, that has already been published? How does Parliament, for instance, go back and expunge Judge Kwesi's name from vote and proceedings or all parliamentary document that has been distributed across the world? Don't you think that the meaning that the Attorney General, the AG, has enlightened in the document before us will be very difficult to implement? What are your views about the matter?
I will not be able to give you my views on what the Attorney General has said.
So, can I put it this way? The Attorney General, in his view, has explained the meaning of your faith relief. Do you agree with the Attorney General's meaning to the faith relief as in your judgment? Or what is the meaning of the faith relief in your judgment?
Would you kindly read the faith relief?
The faith relief says that finally, Parliament is ordered to expunge the name of the first defendant, James Judge Kwesi, as Member of Parliament for Asen.
That is what it means.
And so we then have the minority leader, Kezala Tufosin, then proceed to point out some political difficulties. Listen.
Madam, so if we say expunge, is it going forward or all the records that he has been involved in?
Honourable members, order. Kindly allow the nominee to...
The decision...
Honourable members, can I have some order, please?
Any decision of the Supreme Court is a decision of the court. And it is also allowable for any party who does not understand what the court has said to seek clarification from the court. So I would humbly suggest that if there's anything in our record you don't understand, that you activate the procedures. But otherwise, I don't know what else to say.
So, James, is Justice Tokone worried about what this decision means going forward for dual citizens?
She was not too worried about this. In fact, as an individual, she thinks that we have even progressed as a country with regards to this. She was of the view that the earliest laws of the land did not even allow citizens, Ghanaian citizens, to even hold allegiance to any other country. But we have crossed that hurdle where Ghanaians hold citizenship to other countries. And so she thinks that if we want this to also change, then we need to review the law. But she's been encouraging persons who hold contrary view to read what the provisions of the law is.
What signal do you think is being sent to Ghanaians in the diaspora on dual citizenship, and the signals that is being sent with all the courts brouhaha going on around Honorable Kweson's case? What signal do you think is being sent? And what do you think you would do about it if you become Chief Justice to give comfort to the diasporan community?
You know, under Article 8 in the Constitution, we started out without even allowing dual citizenship. We have evolved. That article has been amended, and we have made several steps towards embracing Ghanaians who take on other citizenship. So I think that in terms of regulation, we are doing well. People have to read what has been put down.
So if you're doing well, then how does that stand with the Kweson's case?
When the reasons come out, you will read it.
So, James, what does the majority stand on this?
The majority actually shares in her view that the decision of the Supreme Court cannot be narrowed down to an individual judge who sat on such matters, and so the public as well as the minority side need to take cue of this. Also using the chairman of the committee, Joseph Osei, was also using the opportunity to advise persons of the public, including lawyers and members of parliament, to be mindful of their criticism of the Apex Court.
But you consider the orders you issued to be executable orders, correct?
Yes.
Right. And the affected party can either appeal, file a review of the decision, or perhaps apply for stay of execution. Now, would you agree with me that in the absence of the judgment, it will be difficult for the affected party to exercise certain rights in respect of the decision? Would you agree with me?
I agree that anyone who obtains a decision from the Supreme Court is entitled to apply for review if they meet the threshold for review of the decision, because there are very clear parameters for review. I also agree that without a copy of the reasons, it will be difficult for them to know. And so it's necessary for them to get a copy of the reasons.
We are the politicians. You pronounce on our conduct. And when there is ambiguity, there's confusion. To get our heads out of the cloud, we need certainty. Right now, Electoral Commission, which was a party to this decision, acts. The Speaker, who must exercise certain rights under Article 1125, may or may not act. I'm saying that though you have the right to pronounce on a matter and reserve your reason for another date, you may have to look at how you approach this or exercise such discretion in matters that are politically sensitive. Else, we are all thrown into a state of confusion, insincerity.
That because of the nature of the panels, we take time with the decisions to make sure that every jot and every tittle is accepted by every member of the panel, because all of us will put our hands to it. But the core content of every judgment is accepted by a panel member who says they agree. So the point you make is well noted.
So in other words, the point I want to make is that the bench must be mindful of decisions that have political connotations, so that you don't set us on a collision course as a political class. That's the point I want to make.
Point is well noted.
And then the chairperson of the committee had some comments to make about this issue of not concluding the vetting.
He thinks that when you look at the structure of the judicial system, he thinks that we all owe the duty to protect the Supreme Court's issues that have been adjudicated over by the Supreme Court in order not to set bad precedent for people to follow and descend on the court in a way that they are not supposed to. He's been giving that advice to members of politicians, members of parliament, as well as the general public.
I regret that the ranking member puts his side view as if it's a decision of the committee.
No, that's not what I said.
You can't say to conclude. You must ask the question before you conclude. No.
I did it.
Let's make it clear. I think that we are confusing our role here. Our role here is regulated by our standing orders. The standing orders, this committee has not precluded anybody from asking any question of any sort. Indeed, there are some few questions I could have intervened, but I decided that let the process flow. So it is open for anybody whilst we are here to ask any question. But please, let's not appear that because a judgment of a court, not her judgment, the Supreme Court, you have not had a copy, it in any way precludes the Appointments Committee from concluding its work. I don't think we should encourage that kind of.
And we also know that one of the issues that's been quite topical has got to do with the whether or not the Supreme Court has in recent times been delivering partisan decisions. What did the nominee have to say?
So it was in reference of this Judge question matter, as well as the issue of the Hohwe MP being his winning of the constituency sent to court, if you remember, and then the High Court made a judgment on that. That scaled down to this Judge question matter. That was the example that was set, and the CJ nominee was of the view that especially when the Supreme Court arrives at consensus, if they arrive at an anonymous decision on a matter, that cannot be concluded as a partisan ruling. The question was that when the Supreme Court, there are issues, especially involving political figures, their conclusion or ruling on the matter try to depict as though they are leaning against one side. And she was of the view that anytime the Supreme Court especially arrives at an anonymous decision on a matter, what it means is that that is the exact position of the law which none of the judges has deviated from, and so those kind of judges should rather be appreciated than be seen as partisan judgment.
I believe your question started with a premise that judges will do the bidding of the appointing authority. Then your question moved into assuring Ghanaians that judges would work independently. Now, it's difficult for me to appreciate what is meant by the appointing authority, because the appointing authority from the for Superior Court judges is the president, and with acting on advice and in consultation with the Judicial Council and the Council of State when it comes to the Supreme Court.
And so when all of this was unfolding, MP for Goshegu Hassan Tampoli monitored. Of course, he serves on that appointments committee and has some inputs into all of this. Thank you, sir, for your time here on Top Story. The issue has come up strongly with divided opinions on the committee itself. You've done some meeting afterwards. Have you concluded on what the decision of the majority side will be?
Thank you very much. The decision of the majority is that we find nominee to have excelled at the rating, to have met the threshold under the Constitution and other extant laws. And I believe very strongly that she has done veritably and ought to be confirmed as the Chief Justice of the Republic of Zambia.
And how about the insistence from the minority side indicating that they would have to defer decision until June 7?
So the practice of the committee is that normally when we are done with the vetting, the public vetting, we go into a conclave and then we take a decision whether or not we should take a unanimous decision or a majority decision if there are some dissenting. On this particular occasion, we had to resort to majority decision because, as indicated by the minority leader, they were of the view that until and unless they get a copy of the reasoning opinion of the Supreme Court in relation to the recent matter, the decision of the Supreme Court that was delivered on the 17th of May, they would not be in the position to join us in taking the decision. Now, we are of the view that under Article 99 of the 1992 Constitution, the power to nullify elections in parliamentary elections rests with the High Court. Now, if you are not satisfied, then you may appeal to the Court of Appeal. In July 2021, the High Court sitting in Cape Coast nullified the elections of Honorable Christian and said that he wasn't properly elected by virtue of the fact that at the time of filing his nomination to contest for the NDC parliamentary elections, he still held allegiance to another country other than Ghana. Now, that is where the decision was taken. It is not the Supreme Court which took that decision. And the minority leader asked the nominee a question today, why the Supreme Court was the one that was taking a decision in the parliamentary election. And the nominee informed the House and the committees and the majority of the Ghanaian people that it is the High Court that took the decision. What was before the Supreme Court was the constitutional effect of Article 94(2)(a). Now, it's the plaintiff who went back because after the High Court had held his judgment, had pronounced his judgment, Honorable Christian continued to come to Parliament and continued to hold himself out as a member of Parliament for the good people of Athens. Now, the plaintiff went to the Supreme Court to seek an interpretation of the scope and effect of Article 94(2)(a). And that is what the court rendered on the 17th of May. So really and truly, if you go deeper, it is not the court that said he is not a member of Parliament, but the Supreme Court was given an opportunity based on all the facts that was before them, that the nullification of the election of Honorable Christian, conform to Article 94(2). The Supreme Court said yes. He said that his election was unconstitutional and therefore declared null and void because at the time that he filed his nomination to contest under the ticket of the NDC, he was not eligible because he held the Canadian citizenship. Now, the nominee was also at pains to explain the workings of the Supreme Court when it comes to matters of this nature. Now, she said, for instance, that when a matter is heard by the Supreme Court, they go into conference and they consider their various positions. And after every position is considered, depending on the decision, the president of the presiding justice of the court will nominate one person to write judgment on behalf of all of them. Or sometimes in instances, she said it, that in some instances you may have 2 or 3 people write different components of the judgment and then they piece it together as the decision of the court. So in this particular instance, we had justices of the Supreme Court sitting on this matter. It's fairly over by Justice Bongote and other justices. So I'll find it very difficult, just like all of us in the majority, that assuming without admitting that there is something wrong, the reasoning of the court in this particular matter, Justice Chitokono should be held responsible for that. That's not to say that the Supreme Court is doing anything untoward, but assuming without admitting that is the case, it will be unfair for her to be held responsible for the decision of the Supreme Court.
And I'm grateful for your time. That's MP for Gushegu Hassan Tampole wrapping up top story. And we know that the implication possibly may be a by-election that will definitely come up within the Asin North constituency. And speaking of by-election, it's been triggering the national conversation, and that will be featuring on Ghana Connect, which is coming up shortly with Evans Mensah. And Evans, the focus is not just on the political class,
no, of course
but
not.
even the voters as well.
I mean, this week you reported again on the by-election, reports of vote buy. We covered the NDC primaries, same suggestions made again.
The 40 Ghana cities.
Yeah, etc., etc. I mean, but sometimes you get tired of the accusations against politicians, etc. But what about us as citizens?
Yeah.
What is our responsibility in all this? Because when you listen to politicians, they tell you that they do it because there's an expectation from the citizens for them to do this, and that if there's no expectation, then they may not be forced to do it.
The delegates call it the cocoa season. Exactly. I'm sure you've heard that.
Exactly. So we need to probably have a conversation. This is what Ghana Connect does. Do an introspection. Take the politicians out of the way and let's do an introspection ourselves. What is our role in all this? We're always complaining that that there's vote buying, etc. But what about our role in this? We'll talk to a politician who tells you that, well, if you go to the delegates, you go to the voter, and you have great ideas, great ideas will not win.
Talk is cheap.
Will not win you the election. Well, what will is your resources, how much money you can bring to the table. That's a conversation that we must have. And citizens, women abroad will connect for that conversation indeed here on Ghana Connect.